When the notice first arrives in your inbox, it might even look like a scam, but cease and desist letters for copyright violations are serious. Thanks for joining us for Expert Connections. I'm Julie Holton. If you have posted an image online without permission or without purchasing a license, chances are you may have violated a copyright. In today's Legal Connections segment, I'm joined by attorney John Mashni of Fosters Swift. John, violations like this one can come with big fines. They might be a lot more serious than people realize.
Absolutely. And there's no question. Copyright is very often misunderstood by many people. In fact, most people, even people who create those copyrighted materials. So I think when you're in business, one thing that to watch out for is exactly what you said. You get a cease and desist letter or a letter, sometimes from an attorney or a law firm, sometimes not. And there's been a recent proliferation of these types of letters that have come out from firms that are not law firms, where it's a very automated process. What happens is photographers are signed up for some of these services, and the services will do a reverse image search on all of the photographer's photos, meaning that it's like Google essentially, except they take an image and they find all of the places online where that image appears, which could be your website. And many times when people are hiring web developers or website programmers, those people, whether they're in marketing or web development, don't always procure the proper rights to use that photo or that image on your website. Well, who's ultimately liable? It's you. It's your company. It's your website. And this essentially means that you're potentially liable or guilty of copyright infringement. And what does that mean? Well, what I often explain to people is it's the FBI warning that you see at the beginning of Blu-rays and DVDs. 5 years in prison, $150,000 fines, right? It's a big, big deal. And you got to be very, very careful if you get one of those letters.
And we often think about protecting our own copyrights, our own assets, but here you're talking about making sure you're not using someone else's. So, okay, let's say you receive this letter in the mail or in your inbox. How can you tell if this is a legitimate claim?
Well, first thing is just assess, are you using this image? And look, do I have the rights to use this image? That's number one. Do I have a license, or did someone give me a license, or do I own it? Did I create it? Where did the image come from? That's the first step. Just make that fundamental assessment. What do I have? What am I using? And immediately, before you even go any further, if you don't have the proper rights, take the image down immediately. Don't even mess around. Just take it down before you even respond. Just make that assessment and do that due diligence up front. Then you have to actually figure out, okay, do I have liability for copyright infringement? There's a couple key factors. One, I think the first step I'm going to look at is there a valid copyright registration? Usually the letter will say whether there is or there is not, but that's going to determine the legal strategy going forward. And you hope that they don't. But if there is a valid copyright registration, and usually you will figure that out pretty quickly, or at least a lawyer could, well, then you are potentially subject to what's called statutory damages and attorney's fees, which means that the person sending you the letter doesn't even have to prove that they were damaged. They just have to show that you used it and they had a valid copyright registration at that time of the infringement. So you could have to pay thousands of dollars plus pay all of the attorney's fees, including the fees to send you the letter that you're looking at. So those attorney fees sometimes are more expensive than the statutory damages. So thinking about that, those two factors, it can become pretty apparent very quickly what your options are. Sometimes you might luck out and say, hey, we'll just stop and we consider the matter finished. Sometimes you might actually have to have some amount of settlement, and there are strategies and defenses that you can have potentially, but you need to look at it with someone that has dealt with copyright issues before, specifically these types of letters.
Now, I want to ask you this, and this might be an obvious answer here, but does this also include social media? Because it seems that people like to share or reshare things on social media. Could that get them into trouble?
Absolutely, particularly if it's a business and someone that's sending the letter figures out that you might have some money to pay. Many, many times these letters come with automated links where you don't even have to talk to anybody. You can just sign electronically the settlement agreement and submit payment online. They are designed to get settlements. That's why we sometimes call them trolls, even though the photographers probably don't like being, accused of being trolls. But the bottom line is that they're going to target people who have the ability to settle and make quick payments. And we're talking about thousands of dollars, $10,000 or more in some cases. So it can really pay to have someone that understands the ins and outs of, okay, what are your defenses? Because sometimes we can get away for $200 or $500 when they're asking for $20,000. So it's understanding those defenses, right? Who's a target? So, I've handled that before where someone posted an image on Instagram, and that their Instagram posts were linked on their webpage. So it was technically on their webpage as well as on Instagram. So again, looking at it, social media can create some liability for you if you're not paying attention to these issues. And particularly now when it's so easy to either hire someone to pay to create images or use various services to create images or find royalty-free stock images that you can use in your marketing and for your business. You can find alternative ways where you don't have liability.
Absolutely. And of course, I'm thinking of stock images that I sometimes see people use with the watermark still on it. That is a sure indication that you should not be using it because you have not purchased the right to that. John, one last question. Again, another one that might seem obvious, but when we're talking about copyrights, who owns the actual copyright to an image? Because I think there can be, and I know this gets complicated, but there can be a misconception sometimes that, oh, well, this is my building that's in this photo, or this is, my place of business. This is someone from my staff. Does that mean that you still have the ability to post that photo?
No, you got to be really careful. I think the misconception is that if you pay for it, you own it, which that's not necessarily true. If they're not your employee, and particularly, let's say they're an independent contractor and you pay for it, ownership doesn't transfer just by paying money for something. There has to be a written agreement, and there has to be special language in the agreement that either gives you a license or transfers ownership. So you got to be very, very careful when it comes to ownership.
John, thank you so much. For additional information from John and the other attorneys at Fosters Swift, just head to our website, WLAJ.com/expertconnections, and click the link for Legal Connections.